And we're live. It is Thursday, November 12th, 2020, 5:03 p.m. We are 3 minutes late because of a sequence of audio problems. I won't detail the audio problems because they're boring, but they are resolved at this point by dint of my wearing this headset. So if you're inclined to make fun of my headset, think again, because if I weren't wearing it, you would either be hearing very low voiced Ben or helicopter in the background Ben, and you much prefer headset Ben to either of those. Meanwhile, the manual recount has begun in Georgia. They continue to count votes elsewhere. And as Chevy Chase used to say about Generalissimo Francisco Franco, the President of the United States is still losing. Some of you will get that. We are not allowed to have fun anymore. But in lieu of fun, we have the disembodied voice.
Hello.
Yeah, there it is, of Ozzy Osbourne.
Hello.
But seriously, hold on. Let's introduce our guest for serious.
Okay, let us introduce our guest for serious. Kate, why don't you do that?
So we have David Allen Green. David has been a frequent recommendation from the audience, and we were lucky enough to, because I know we were supposed to be scheduled with somebody else today, but there was an emergency, and David was on standby, and so this is a wonderful treat to kind of fill out our generalist week around the presidential election and the aftermath. He is a legal correspondent for the Financial Times, and he has his own blog where he talks about law and policy. And you're a columnist at the Prospect, in the, not to be confused with the American Prospect, the UK Prospect. And we are really glad to have you on the show. Thank you so much for coming, David.
Well, thank you. Strictly speaking, I'm not legal correspondent of the Financial Times. I don't actually go out and do any reporting. I just sort of sit back and commentate. So I'm legal commentator, which is actually
I see now. You're a contributing editor. The various biographies that the internet gives you are incorrect.
Yeah, contributing editor is a very grand title for a freelancer.
Yeah, right? So I've been trying to get one of those forever. What is
I know. I was just given it like some sort of title in the Duchy of Ruritania. Oh, you're contributing editor now. And I thought, oh, that's great. And it sounds wonderful. I'm not quite sure what it means. It still means I get edited, and it still means I have to go through a commission process, but it's a nice title all the same.
So my question is, are you also still a practicing lawyer, or is the commentary a kind of full-time gig at this point?
It's a bit of both. I am a practicing solicitor. In England, we have a divided profession, as you know, between barristers and solicitors, and I'm one of very few who are actually qualified to do both. But you only can practice as one or the other. So I am a qualified barrister, which tends to be the people who do the trial advocacy. But I practice as a solicitor, who are the people who tend to do the correspondence for conducting of litigation and the dealing with the clients. And I am a practicing solicitor in the City of London, where I tend to do a lot of media and communications law. But as a commentator, I do constitutional and public law. So there's a bit of a Chinese wall there. If I commentated on the sort of law I practiced in, there would be all sorts of conflicts of interest. So I tend to commentate on areas of law which I don't practice in. And so I have this sort of divided interest in law between, on one side, media and communications law, and on the other side, public law, constitutional law, Brexit, and related areas of law, and also the law relating to torture and human rights.
And how did you get into the commentary side? I think like everybody who is a media, who does law in the form of writing for the public or commenting for the public, there's a story behind it. What's yours?
Well, before the internet, I wanted to do legal commentary, but I'm quite useless with deadlines and word counts. And so I didn't get very far. And then the internet came along, which meant that you could post things as and when you wanted to, when it seemed appropriate, and you could do so in the form that seemed appropriate. And also, writing for the screen is a particular skill. It's very difficult to write well for the screen, especially if you're used to writing for print publications. And so when the internet came along, I started blogging, and I had a blog which wasn't about law and actually had some of the worst writing on the internet when I tried to review operas. And then there was a big libel case in England.
That's a hell of a competition, the worst writing on the internet.
I've managed it. Imagine a law blogger writing about opera, and you would have the blog posts.
This is like basically Ben's dream, is to write about opera as like a legal writer. Ben just sings it instead. He just goes straight for it.
I just want the record to reflect, I have never sung opera on In Lieu of Fun.
No, you've sung Gilbert and Sullivan on In Lieu of Fun.
Yeah, that's very different.
That's true.
But about 10 or so years ago, there was a big libel case in England where a science writer called Simon Singh was sued by an association of alternative medical practitioners called the British Chiropractic Association. And suddenly everybody, well, not everybody, but quite a few people around the world just wanted to understand how English libel law worked. And I understand how English libel law works and doesn't work. So I started this blog called Jack of Kent. And that quite quickly got loads and loads of followers, not because of the writing was any good, but because people were inherently interested in somebody explaining law in a practical live case, which was actually quite rare in England, because in England, the newspapers and the media sites tended not to write about live cases. They usually just go silent during a live case. And I was writing about a case, the result of which people didn't know. And then there was another case not long afterwards, which was known as the Twitter joke trial, where right at the beginning of social media, somebody made a joke on Twitter about blowing up an airport. It wasn't serious. But the police didn't know any better and then prosecuted them under the Communications Act for a menacing publication. And in that case, both as a solicitor and as a communicator, I explained the case and then forced it all the way through to the Lord Chief Justice and won the case. And I thought, oh, this is interesting. I enjoy writing about the law on a screen. And so a magazine called The New Statesman took me on as a blogger, and then the Financial Times took me on as a blogger. But I actually think blogging suits writing about law, because you can click onto authorities. If you don't agree with what I'm saying, you click, you see the authority on which I'm relying.
I love that you say that, because I also think that, like, I came up, I'm a little bit younger than you, I think. I'm not sure. Based on the age of your voice. But mostly I think that, like, I grew up kind of reading balkanization, and Ben, you'll even say that this was the genesis of starting Lawfare, was balkanization and Talking Points Memo, and like a number of kind of the blogs that were kind of came into being that broke out points of like. It's interesting. Two questions. One, why do you think it was that like the English system did not follow it breakouts and cases and trials? That seems just inherently like interesting to me. Or I mean, and your following on Jack of Kent seems to have like supported that conclusion that people were interested in it. So it's weird that that never happened. And then before kind of the internet. And then two, what is like the state of of UK media now in terms of covering trials? Has there been a sea change in how these trials get cast? And then eventually I want to like kind of pick your brain about defamation law in England, because defamation law is something I specialize in the US, and it's just so different international communities don't seem to know particularly don't seem to appreciate how different the standards and burdens of proof are in the two areas.
So wait, but before we get to the distinction between British and American libel law.
English, not British. Scotland has its own system.
Yes, sorry, yes.
We have to, there's an antecedent question that we need to resolve that Alice posed on behalf of probably 70% of the people in the chat, and I suspect more like 90% of the people who are watching on YouTube. And so to bring people up to speed, Alice, pose your question, and this will help everybody get through the rest of the conversation.
Yeah.
I post chats so that I was here, but here we go. The difference between barristers and solicitors were, because I think my only touch point for British law is that scene in the beginning of Two Cities. I think that's all I'm going on. So.
Yeah. So this distinction, and you know, maybe use it to talk a little bit about how the UK system and the American system, I mean, the educational system for lawyers is completely different as well. So, like, walk us through a little bit how these systems, the legal practice is different.
Well, I have a bias insofar that I don't think there should be a distinction. I am one of these people who believe there should be what's called a fused profession. It seems to work elsewhere in the common law world. No reason why it shouldn't happen in England. I also was trained at an American law firm called Baker & McKenzie, where everybody was essentially all the litigators were supposedly able to do all parts of the job. So I'm afraid I have a biased view of this. The main reason is historical. Solicitors used to be known as attorneys, believe it or not. And barristers used to have rights of audience in certain courts, and attorneys used to have rights of audience in certain courts. And by the late 19th century, you essentially had two groups of people who were court lawyers who had their own privileges. It was like a guild. And to be able to plead in a certain court, or even to put your name to certain documents, you needed to be part of one guild or the other. By the early 20th century, that had become structured so the lawyers who tended to do the oral advocacy were barristers.
So does that include any type of appellate work as well?
Yep, generally appellate work.
Barristers tend to be in court before a judge.
Yeah, but barristers tend in England to be self-employed. You don't have firms of barristers. They might join together in what are called chambers and share expenses and administration, but barristers tend to be self-employed professionals, and they specialize in advocacy before the court and advising on particular areas of law, and they work for a whole range of solicitors firms. And so a barrister who specializes in public law or criminal law or whatever will have a range of solicitors firms who will then instruct her or him. So it works because it means solicitors, those of us who face the clients, can pick and choose which trial advocates and specialist advisors we can instruct, and in turn, the barristers are there and are available for anybody who wishes to instruct them. So it does actually work, but it's a very odd system.
So just to put it all together. So let's say you're filing a brief. You have a case that's an environmental law case, right? And so basically the solicitors would do all of the legal research, all of the issues, brief all of the issues, write up the brief. They would have the ability to put their name on it, file those documents with the court. Then that group of solicitors, or that, maybe it would be an individual solicitor, whoever it is, but the solicitors, if it was a firm, would go and hire a barrister that may be specialized in environmental law, and a barrister who is somebody who is maybe especially good at public speaking, in addition to having a full kind of expertise of thinking on their feet about environmental law. Like they're not just like a actor, right? They're a person who has a huge background so they can think on their feet and respond to questions about environmental law. And then they take the briefs of the solicitors and like present them before the court.
No, I'd characterise it slightly differently.
Okay.
What happens, especially if it's serious litigation, if you are going to go to court, you instruct the barrister at an early stage. Because the barrister does two things. The barrister does what you've just described, which is for standing up in court and persuading the tribunal.
Mm-hmm.
Yes, that's what the barrister does. But the barrister, because they are so experienced in doing the tribunal work, will be also able to advise you on the merits of your case, whether it is worth bringing, how to formulate it. And if you are clever as a litigator, you bring the barrister in at an early stage so that all the paperwork is such that the moment you do file it at court, everything's in place. And so essentially the barrister is court looking. It's like Janus. The barrister looks towards the court, tells you what the strengths and weaknesses of what your case are, and if it does go to court, then seeks to be persuasive. Whilst the solicitor looks back towards the client and explains to the client exactly what is happening, what the strengths and weaknesses are of the case. In America and other common law jurisdictions, the same lawyer does both roles. But historically in England, you have different lawyers who differ, and it does kind of work. And in Scotland, you have a similar system, but the barristers are called advocates.
Okay.
And explain something to me, though. Where does this distinction, when does it first show up in historically? I find it hard to believe that in the sort of dawn of the common law, there was this hyper specialization of roles in legal practice, right? When does this division of labor develop?
It doesn't. It's the other way around. The division of labour was there from the beginning. Different sorts of lawyers had rights in certain different sorts of courts. And then when you guys go off after 1776 and do your own thing and have your own unified profession, and then look backwards and say, oh, how did that hyper-specialisation develop? No, that was actually what it was like to begin with. And it's how it continued in the jurisdiction over here. We just had different courts with different lawyers who had different rights of audience.
I think we just didn't have the depth of. I think that it was out of. I always had learned that it was out of necessity that the profession got combined. Like there just weren't both barristers and solicitors to do those roles, and so it was like it became by necessity a combined role. And then stayed that way, at least in the U.S. It's very interesting because it's kind of like becoming a doctor, becoming lawyers. Those are two professional schools that are just very, they're very, the paths for them are very set out in the U.S., as you know, and it's very different. So one of the things you haven't mentioned is that there isn't like a professional law school to become a solicitor, but there is to become a barrister. Or how did the schooling work to become a lawyer?
The medical analogy, which is often used over here, is between what we call general practitioners, who are your sort of high street or what you would say Main Street doctors who deal with everybody, and then you have the consultants at the hospital, a bit like House, who deal with particular diseases. And that is the distinction. Your solicitor is there to meet any client who wants to come towards her or him. And then if the case is particularly tricky or looks like it's going to end up before a court, you then consult a barrister in the same way you would consult a medical consultant. It is an odd distinction, but it does seem to work in a certain to a certain extent. But there are a couple of problems. For example, as a solicitor, if somebody comes to me and says, I want to instruct you to do a piece of work, and I think, no, I don't actually want to act for you, I can say no. A barrister can't. We have what's called the cab rank rule for barristers, for advocates. It doesn't matter how odious your client is. If you are a barrister and that person comes to you and instructs you to act for them or asks you for advice, you actually have to give them the advice or act for them. in what's called the cab rank rule, i.e., you rate as a cab and you pick up the first person who hires you. And that means that everybody in England and in Scotland has the possibility of having a first-rate advocate, because the advocate can't pick and choose and go, oh, I'm not going to act for you, I don't like your values. The advocate actually has to act for you, even if they suspect you're guilty or whatever, because you have got to them first and they instruct you. And it in a way facilitates access to justice in a far better way than pick and choose way.
What about in civil matters? So we have an ongoing dispute in the United States right now about the law firms that are representing the president in these frivolous lawsuits in the electoral context. And the argument has been that these two major firms should not be handling these representations because they're vexatious and entirely meritless. They are on offense. They're not, this isn't a defense, much less a criminal defense. It's these are civil litigations, and they are they're vexatious and designed to undermine confidence in the electoral system. And so a lot of people are saying, hey, Jones Day, should cut it out. Would this not be a question in the UK, or is the principle that you're arguing about, that you're articulating, only in the context of criminal litigation?
No. It for the solicitor, it would be a choice. You would be choosing to act for Trump or whoever. For the barrister, they instructed to actually go and do the court advocacy, to go up and go to the High Court in London, or go to the Court of Appeal, or go to the UK Supreme Court. It wouldn't be a value judgment. It would be that they had instructed that barrister first and they were obliged to actually fulfil those instructions. But for the solicitor, and Jones Day have a London office too, it would be their choice. And if there's a hit, a reputational hit, well, they chose to act for that client.
And why is there a distinction for this purpose between barristers and solicitors? I mean, if the principle is that everybody is entitled to good legal help, I'm not sure why that, and to appropriate representation, I'm not sure why that's any different with respect to the advice that you receive than it is with respect to the representation in court that you get.
Numbers. There is the barrister's branch of a profession is very small compared to the solicitor's branch. And so there's always going to be very few skilled advocates in any area of law. And so if they were able to pick and choose, you would end up with a situation where people would not have any right to representation. There are defense firms of solicitors, there are prosecution firms of solicitors, there are what we used to call plaintiff, probably should still call plaintiff, but we now call claimant firms of solicitors. You would not be able to have the monopoly on advocacy which a bar has, and for them to pick and choose. So the real difference is the availability of counsel, as you would put it.
Talk about legal education in England. We have a lot of people in the United States are surprised to learn that practice of law in the UK is based on an undergraduate degree. Actually, I think the United States and Canada are kind of the exceptions in this regard, and you guys are sort of more the norm. What does it take to become a solicitor, and what does it take to become a barrister?
Well, I haven't got a law degree.
What would you say?
I haven't got a law degree.
You haven't got?
No.
Yeah. Wait, you didn't even have a law degree in undergraduate?
No. I've got a history degree.
What is your degree in?
I've got a degree. I've got a history degree. I've got a degree which actually trains you in assessing evidence, which is quite useful as a lawyer.
Yeah. No, it actually really is.
We have a system.
If you're a 15-year-old in the UK who says, I want to be, a lawyer, like, what's the track? What does it look like? How do you do it? It goes
like this. You can do a law degree, which we call LLB, which is 3 years, which is basically 2 years of your core components plus a year of doing options. You then do a year of vocational training, either as a solicitor or as a barrister, and you then go to a solicitor's firm or a barrister's chambers. So it's 3 years degree plus 1 year's vocational training, plus going then into a firm of solicitors or a barrister's chambers. If you don't do a law degree, you then have an additional year, which is called the General Diploma of Law, where you do the first 2 years of a law degree in a year as what's called a conversion course. And you then go on to the vocational course, and then you go on to either a solicitor's firm or a barrister's chambers. So I did a history degree at a university called Oxford. I then did a law conversion course at Birmingham University.
I've heard of that one. Wait, Oxford? Yes. Okay.
Yeah. Oxford, 3 years of history at Oxford, then a year of law at Birmingham, and then I did the bar vocational course and then transferred over to being a solicitor. So basically,
bar vocational course, like reading the law, like is it like an apprenticeship type thing, or is it more like classes and lectures?
It's a bit of a mixture, but essentially it's just teaching you how to set out pleadings, and how to stand up in court and say the right thing. So straight answer to your question is either a non-law degree plus a year of law, or a law degree.
Got it. Okay.
And then a year vocational, and then into the profession.
All right. Christopher Argyris has an interesting perspective on all of this because he's an American in London in the legal profession, right?
Yeah. So I'm a law PhD. I got to do the PhD in the UK, but I'm neither qualified as a lawyer in the US or UK. So I'm more of a legal scholar and legal consultant for like UN type work. But and I've taught public law in the UK as an American. So one of my sort of comparisons and sort of maybe a question for David would be, do you see the UK adopting more judicial review? I mean, that's because I would say that's the major difference between the US and the UK in terms of what the Supreme Court and federal courts can do in terms of just straight striking down laws or challenging laws, based on but that's not directly the case in the UK unless it deals with the Human Rights Act.
You've asked the question I've always wanted to be asked by an American, which is, how do you explain English public law? And the answer is...
I have to just say how esoteric this conversation is, and I'm digging it. Like, it's awesome. Hold on, go ahead.
Well, hang on to things, because we are terribly confused about public law in England, because in a way we actually don't have a system of public law. In England, historically, we had no conception or conceptualization of the state. What we had was the Crown. The Crown, from Crown in Parliament, the Crown in the courts, the Crown using the royal prerogative. You also had corporations, parish councils, and whatever. You had this fragmented system of different bodies doing different things. And you had various remedies against them depending on what the source of power was. Was it a source of power because you were a statutory corporation? Was the source of power because you were acting on behalf of the Crown? Or whatever, but there was a complete mismatch. And even now, in 2020, we do not have a unified conceptualization of the state in English law. Different bodies have different powers, different remedies against them. And that sort of worked to an extent until the 1940s. And so until the 1940s, you did not have a sense of public law in England. You had something called the Law of Proceedings against the Crown, with incredibly Dickensian legal fictions and processes to follow. Jarndyce versus a Jarndyce everywhere. And then in the 1950s and 1960s, a group of senior lawyers around what was the House of Lords, which was then the Supreme Court in England, especially a great judge called Lord Reed, started trying to systemize English public law. So you had the same grounds for finding things illegal, the same processes for actually bringing a case. And so you had this, shall we say, pragmatic Anglo-Saxon approach to problem solving of having a public law in type. So we took the old doctrine of ultra vires, which was essentially obviously acting outside of one's legal powers, and then somehow attached that to the Crown, even though, as a matter of doctrine, the Crown is omnipotent, and so on. So we had a lot of these cases, and then by about the 1970s and early 1980s, we had something which you could point to an American guest and say, yes, that's our public law. But it is a very confused thing, and even now it's not terribly consistent. But we do now have a sort of situation where if anybody exercising public power, regardless of the source of that power, whether it be the Crown or a statute or whatever, there are certain things they cannot do, certain things they can do, and there is a unified process for challenging it. But my God, it's been fairly difficult to actually get there as a matter of legal theory and legal practice.
Before we go to Pauline's question, I want to first of all say, like, this has been incredibly interesting to have this explained, not because you're British, but because you are so well informed from a historical and legal perspective, I would say, to explain kind of this differential between the US and the UK systems. I have one of the things that, do you think we should talk about Trump and the election first, Ben, or do you think we should pivot to Brexit stuff?
Well, let's do a quick question on how absurd we look as Americans.
Yeah, that's
from
a good
across
question.
The Atlantic. I mean, like, how embarrassed should we be?
Well, you look absurd. We look absurd. The French are laughing at both of us.
Well,
we gotta do so.
Everyone always laughs at the French. So
if the special relationship is worth anything, we gotta get together and do something about that.
For the way I look at how it has developed in America and in the United Kingdom is that both of us were hit by a tidal wave in 2016 called populism. That wave is now receding. We have been left with us being outside of the European Union. You have been left with a federal bench stuffed with conservatives for the next generation. Both of those are going to be immense hangovers for both of our respective countries to deal with for quite a long time. And that is the reality of the situation. But
at least we're not Italy. Sorry.
Well, I think
have a Berlusconi figure.
I know, exactly.
I think that Anglo-American arrogance or complacency is more or less over. How can either of us say to anybody else, "Oh, well, we've got a system of government which you should look up to"? Both of us have been shown to have our weaknesses. Some people think the United Kingdom does not have a constitution because we don't actually have a codified constitution in the way that you guys have.
I've heard that.
But we do have a constitution, and it is a written constitution. It's just not written down in one place. It's written in a whole variety of legal texts: Acts of Parliament, Books of Authority, Rules of Procedure. What has happened in the United Kingdom, I would say, is as follows. We had some really big, high-level challenges to our constitutional arrangements. We had a government that sought to take us out of the European Union without an act of Parliament, just by ministerial fiat. That was the Article 50 notification business. We had a government that sought to force us out of the European Union without a deal. We also had a government which shut down Parliament for 5 weeks at the key point. In each of these three high-level points, the Constitution did creep into action and the government was stopped. The Supreme Court stopped the government taking the United Kingdom out without an act of Parliament, out of the European Union. It stopped Parliament being closed down for 5 weeks, and Parliament stopped the government taking us out without a deal. So at the high level things, our constitution worked. Where the United Kingdom constitution works less well is at a low level stage, not in the big sort of set pieces and confrontations, but in ongoing attempts to bypass Parliament by secondary legislation. We now have a system where, in many ways, we have government by decree. Ministers announce laws, those laws take effect within moments. That cannot be good, that cannot be healthy, but that is what is happening. So our constitutional arrangements over here have worked very well on the big set pieces, the big grand battles on the war games board, less good on the day-to-day stuff. Looking at you guys, you have survived 4 years of Trump. Some people didn't even think your constitution was going to do that. You have 70 odd days left. You got 70 odd days left.
And 230 years without you guys.
Well, we can take you back if we want.
Yeah, I know.
Or we can both go and join Canada, which would probably be most sensible for both of us.
Let's all join Canada.
Yeah, we have a big Canadian component in the audience. I think we should just let them rule.
Can't they just sponsor us? Pauline, can Pauline sponsor me? Like to come to go to Canada?
But your constitutional arrangements have seemed fairly robust over the last 4 years. There's been very few constitutional conflicts as such, as far as I can see from across the Atlantic.
There's been talk of them happening. Like there's been constitutional crisis has been thrown around more than ever. I've heard it in the last 20 years of memory, but you're right. It has held up.
The question is whether it's going to hold up over the next 70 odd days with this sort of very strange, phony situation you have, where you have Donald Trump essentially as storyteller in chief of giving this narrative of not having been defeated and the implications of that. But other than that, it would seem to me that the American Constitution will get out of this relatively unscathed, whilst the British Constitution or the United Kingdom Constitution looks as if it's going to be fairly badly affected by.
I'm not sure unscathed is the word I would use for our Constitution.
I did qualify it by fairly.
Yeah, he did say fairly.
I just think fairly is doing a lot of work. Paul, let's take some audience questions, which is a good
we have
way
some
of
really good
pivoting
ones
to Brexit, because a lot of audience questions about Brexit. Starting with Pauline
from
Pauline,
Canada.
It's good to see your face.
Hi, Pauline.
We all want to refight the War of 1812, and except we want you guys to take us this time.
We won, eh?
Yeah.
Well, that's
kind of.
Sort of, yeah.
Nobody won.
We won. Yeah. The question, however, is, can you explain Brexit?
Yes.
You should also say that that's intentionally vague.
Yes.
I can explain Brexit because I've actually been commissioned to write a book on Brexit.
Oh, really? Cool.
Yes.
That's excellent.
Yes,
we'll have to have you on again when you finish that book, if we're still doing this.
I've been writing it for some time. It was commissioned by Oxford University Press right at the beginning of Brexit, and
Great. It's a great press.
The problem I have is with something like Brexit is, what are you seeking to explain? What is the stare decisis? What are you trying to explain? And working backwards. And at the moment, it's still not quite clear what Brexit is for us to be able to explain what caused it and what the consequences are.
I'm so glad you said that.
In a very strict, narrow way, Brexit is about a legal, technical question. The question is the United Kingdom a member state of the European Union? There is a finite number of members of the European Union. There was 28, there's now 27. Is the United Kingdom in the column of lists of members, yes or no? And the answer is no. the Brexit question on the referendum back in 2016 was whether the United Kingdom should remain or leave the European Union. There was a bare majority, 52%, for leaving. That is what's happened. So in one way, Brexit is very straightforward. There is a vote for us to no longer be a member of the European Union, and we are no longer a member of the European Union. The problem is that there are all sorts of implications of those two things. What does it mean for us not to be members of the European Union? Does that mean that we are no longer part of the so-called single market? Does that mean we are no longer part of the customs union? If so, what is the relationship we should have with the European Union? Is it about taking control of our borders, our currency, our laws? If so, what does that actually mean in practice? On the back of 45 years of integration. So, for example, if you took a state of the United States and imagine for some reason a state voted to leave the United States and the Constitution of the United States allowed that, just for the sake of exposition, and then somehow tried in 2 years plus to work out all the legal mess that would cause vis-a-vis all the other states in America and the federal system. That's what the United Kingdom's trying to do in a hurry. And that is what's making it so difficult, is it's an immense task to reverse 45, almost 50 years of legal integration in just 2 years very quickly at speed without really thinking through what is the arrangement we want on the other side. So in one way, Brexit is very easy. We are not, as a matter of public international law, a member of the European Union anymore. Okay, that's happened. But everything else, incredibly complicated.
Yeah.
All right.
I'm
So Alina
loving
cannot join us. Alina cannot join us on screen, but I like her question, as do 20 other people. So I'm going to read it. She asks, what do you make of the possibility of the Scottish government investigating Trump's deals in Scotland under the unexplained wealth order? And I just want to point out that the UK, you guys really know how to do names of laws. We don't have laws named like the unexplained wealth order. It's kind of an awesome name. I have no idea what it is or whether the Scottish government has the authority to investigate Trump deals on it. But I just think the UWO deserves its time in the sun.
Well, the answer to that is on two levels. First of all, in the particulars, I don't actually know about that particular order. And the second thing is Scotland has an utterly different system of law to England. That is why so far in this conversation, I've been quite careful to say I am an English lawyer, not a British lawyer or a UK lawyer. Scotland's system of law is akin to France's system of law. It's a civilian system of law. We just happen to be part of the same United Kingdom, but it has a very different system of law. To a certain extent, I understand Louisiana has a civilian system, and Quebec has in Canada. It's a similar thing over here. So for two reasons, I can't opine on Scottish law. First of all, it's as more alien to me than your law is. If I was asked to construe an American contract, I would have a go. I would say I'm not an American lawyer. I would go over all those endless inane block capital clauses, which are a misunderstanding of what it is to make something prominent under your commercial code. But I'd be able to explain an American contract. If somebody showed me a Scottish legal document, I'd say I have no idea. So I'm afraid I can't give an opinion on that, either in the particular or general.
All right. David Botts, the floor is yours.
Greetings. Even with the release of various Trump tax information, there are some significant questions about his activities. from your perspective, what areas of international or transnational focus would you suggest to enterprising journalists or investigators? And then part two, to get back to Brexit, is what in your sense might be the impact of a failed Brexit negotiations to folks, say, in the United States? Thank you.
Well, on the first point, I would say the most important thing for a journalist is presenting the story, because the investigation part of it, finding out the facts, finding out the sources, that's been done. There's nothing new to be told about Trump. Almost all the incriminating evidence is there in the public domain. It's just that nobody cares. The problem about Trump and about Brexit is not because the media has been in any way lazy in exposing the lies and exposing the falsehoods. It's just
exactly
because
right.
people have not cared about the falsehoods and about the lies. And until and unless you can make people care that they are being lied to, it doesn't matter what investigative journalists do. People will still just nod along with the narrative which is being promoted by the storyteller in chief. And this is the problem. And it is not that there are things which are left to be exposed. The problem, the challenge, the predicament of the media is to convey that to people so that they actually care about the stories. And that is where the problem has been.
All right. Esther, the floor is yours. You have a couple of good questions in there. I leave it to your discretion which one you want to pose.
The upvoted question was if you would please discuss the recently proposed change to the previously negotiated agreement with the EU regarding Northern Ireland. Still going to slip in my personal question. Are there any Commonwealth nations that still appeal to the Privy Council as their final stop? Thanks.
Answer to the second one, yes, there are still territories which go to the Privy Council. At the Supreme Court in London, which actually is a really lovely former local court, which just happened to be situated in Parliament Square. And
what?
Oh, we lost you.
We losing you? Can you hear us?
Oh no.
Uh-oh. Let me
You want to I will say things.
Yeah, why don't let me try to I'm going to remove David and then bring him back in.
Yeah, that was weird. I will let him know that you're doing that.
Oh, I think he probably just heard me saying that I was doing that.
Yes, hopefully.
So let's bring him back.
Well, this has been an absolutely like marvelous like couple of like almost an hour. I've learned a ton, and I feel like I've had some really, it's been really, I don't think I appreciated having someone with a legal like how great it would be to have someone with a legal background kind of reflect on the similarities between Brexit and the last, the respective issues going on in the UK for the last number of years and the ones going on in the US, although I was very aware that they existed. But I thought it was going to be more like get your act together a little bit, like around the election and everything else. But there was more empathy there, so that was kind of nice. By the way, Ben, have you heard anything about any of the lawsuits? I didn't see anything today.
I have not heard any movement on any of them. So I am unable to get David back in, which I think may mean he has had a Crowdcast says he's still here, but okay. I am not convinced that that's actually true. I think this may be an internet connectivity issue on his part. So David Allen Green, if you can hear me, can you please say something in the chat so that we know you're there? Otherwise, we're going to assume you have vanished in a puff of smoke, been consumed by the
Don't say it. Nothing
the
ate
gods.
him.
What?
I don't think anything ate him. I'm hoping that's it. I know.
I think David Allen Green may not be here anymore.
Yeah, but I did send him a message on Twitter, so he might just have had internet issues. I heard some background noise for the last few minutes, so things might have been fading anyways. But I sent him a message on Twitter. We'll see if he comes back. But it was good while we could get it.
Hey,
it was amazing.
sometimes in lieu of fun runs over an hour. Sometimes it's what did Bill Barr do?
Wait, Bill Barr strikes again? I don't. Oh, maybe he's saying that Bill Barr ate our guest. I don't know.
No, I don't think Bill Barr consumed our guest. I think our guest would have been consumed by Boris Johnson.
I know, that's true.
All right, I think our guest has vanished in a puff of smoke.
And we're 5 minutes from end, so I guess no, I don't think we've. Yeah. Do you want to have a last, Christopher? Do you want to give last words? I don't know if they had questions that were super specific for the guest. Christopher, did you kill our guest?
No.
Did you
disappear our guest? You're the closest one to him.
I know. Well, I didn't know whether he's in London or Birmingham right now. But anyways, no, I was going to ask him about the special relationship, which I think it's sort of interesting from a UK perspective. I don't know whether you guys picked up on this in the US, but they sort of saw Barack Obama as kind of not an amateur, but sort of naive, inexperienced, and especially his views on Brexit, telling Britons how to vote. I think that might have, depending on what pollsters said, because pollsters were very close on Brexit, and him telling them don't do this, or you'll be at the back of the line negotiating a UK-US trade agreement might have made some perceptible difference in sort of pissing off Britons, because but again, there's a lot of similarities between the US and the UK in terms of the Trump vote and the Brexit vote, in terms of people feeling ripped off or disenfranchised, and
right. One of the last trips I did was to give a talk at the London School of Economics before the pandemic. And this is one of the things that kind of we ended up getting into a conversation about afterwards at the dinner, which was just kind of some of these things. But the people that I was having dinner with had the impression, who are all lawyers and who are all very educated, had this impression that had also become spin, that it didn't really matter what Obama said or whatever, that the idea of an American weighing in on on something related to a UK election was just that was a bridge to that was going to be spun no matter how what happened. So whether it had an impact or not was not really the story, was not really the neither here nor there, but that was kind of, that was actually, I think I was there 5 days before Brexit went into effect.
So we're going to wrap up, but before we do, I do want to address a question that Michael Nelson posed. I tried to bring him in to pose it before, but he also disappeared in a puff of smoke. And he says, this is a super timely question for Kate and Ben. What do you think of the rumor that Chris Krebs, cybersecurity hero at DHS, thinks he's going to be fired? And so, Kate, do you have thoughts on Chris Krebs?
I am more interested to know who is put in his place.
Yeah, I don't think we know the answer to that. So
I don't know. Which, but no, and I've heard similar. Yeah, I don't know what's going to happen. I don't have any more information than probably anyone else. So what do you think, Ben?
Well, so first of all, the story is, the story that Reuters ran is that Krebs has been telling people that he expects to be fired. It is kind of amazing that he made it this long.
Yeah.
He's been the premise of Michael's question, which is that there's something heroic about what he's done over the last 4 years, is correct. I mean, he's actually run a professional cybersecurity policy shop at DHS that's done really good work in the election security department, has had substantial accomplishments in the face of the Trump administration and Trump's hatred of anything that implies that Russia might be doing what we all know Russia is doing. And so Chris deserves a lot of credit. It is not surprising that he's finally run afoul of the president, who's busy firing half of DOD.
Yeah.
And so I wouldn't be remotely surprised if it happens. I do think it would be a mark of honor for Krebs if it happened. It is also the case that I think Krebs is one of the very few officials of this administration who a Biden administration might be inclined to retain. And so
I agree with all of that, except I don't think
Hello?
it's necessarily, I mean, it might turn into a badge of honor with the Dems.
David's back.
Oh, is he?
Hello?
Can you hear us?
Oh my God! The disembodied voice, thank God. I was getting worried.
Terribly sorry in that very British way, but I had an outage.
Oh,
It
no.
happens.
We totally understand. I'm just glad that everything's okay. I was tweeting you and I was like, uh-oh. So glad that you're back.
But if I was conspiracy minded, I'd blame all sorts of people for that. But in fact,
we blame Bill Barr. You might blame Donald Trump, but
No, I blame Dominic Cummings.
Boris Johnson. Fair enough.
Well,
Anyway, I'm happy to carry on answering the question which was posed to me, but
Indeed.
obviously
Let's
a lot of
finish
things have gone.
let's finish up that question and then we need to wrap up.
Yeah, the question was about what's happening with the strange piece of legislation which is before the United Kingdom Parliament about Northern Ireland. And this really is extraordinary. We have an Act of Parliament, a potential Act of Parliament, it's still called a bill, which explicitly provides that the government can break the law. Okay, just a moment's thought will make you realise that that is a little bit of a paradox, if not a contradiction. An Act of Parliament empowering the government to break the law. And I'm not exaggerating. The minister said in the House of Commons that this legislation is there so the government can break the law. The law being the protocol to the withdrawal agreement, the Northern Irish Protocol, which is part of the law of the land. And what then happened was that majority of MPs voted for the government to be able to do this. The European Union looked at this and thought, this is odd. We're doing this. We've just entered into this agreement with the United Kingdom, and now the United Kingdom is trying to reserve itself the power for breaking the agreement it has just entered into. This was not just some sort of international law which was because it had been imposed upon the United Kingdom by some assembly far away. It was something we'd actually agreed to just months ago. And so this has caused, quite rightly, moral hazard, because the European Union and other countries just think, well, what's the point of agreeing an international agreement with the United Kingdom if they're just going to renege on it? And so we do have a problem here. And the British government are insisting on having this power, and the European Union are quite rightly saying, well, this makes us really uncomfortable.
This has been such a I hope you don't feel put on the spot answered all of these questions for unfamiliar Canadians and Americans. But it has been a really useful and educational conversation today, and thank you so much for making the time, David. We really appreciate it, and for staying up late on our it must be like 11 o'clock over there, so
well, it's an extraordinary moment for both our jurisdictions, because in my jurisdiction we have a government that's explicitly trying to break the law and is about to leave the European Union after 45 years, possibly without an agreement. And you guys have a president who's refusing to concede defeat and leading to all sorts of questions about coup d'etat. And so if public lawyers and law and policy commentators like us can't have a conversation like this across the Atlantic at the moment, when should we have it?
Indeed. And let's continue the conversation as the respective crises develop.
Yeah, we hope you'll come on. Yeah, we hope you'll come on again. I'm serious. And I don't know if I can ever be any help, but if you need someone to explain Section 230 to some Brits, I'm around.
It's great to meet you. We will be back tomorrow, 22 hours and 56 minutes from now. We will try to reschedule David French, who had a bit of a personal emergency today and had to defer. So we will be back. We're not sure with whom tomorrow, but that will happen. And until then, we don't have fun anymore. But in lieu of fun, we do have transatlantic competitive angst. And we try to outdo one another in our ennui for and our sort of laconic anxiety about democratic functioning. I think right now coup beats lawless Brexit, but I could be persuaded the other direction.
Well, just as a final comment from us, can I just pay tribute to the excellent, extraordinary blogging and other commentary associated with Lawfare.
You're very kind.
It has been exemplary, and it may have had a great audience in North America, but can we say from over here, wow, well done, fantastic
Thank
legal
you so
blogging.
much. It's very kind of you, and we never expected it to have an audience beyond about 20 people in the government. And the idea that it has, like, we really designed it for really, 1,500 lawyers in the government, and the idea that it's read anywhere else is mind-boggling to me. But you're very kind, and let's do this again soon.
Think of it as the BBC World Service in reverse. Thank you.
Oh my God.
See you soon.
Bye, David.
Bye-bye.